Right, live back with you tonight on In Focus. The Constitutional Court has dismissed with cost the Tourism Department's leave to appeal the Supreme Court of Appeal judgment. The appellate had ruled that it was unlawful for the ministry to require businesses to meet B-BBEE in court to be considered for COVID-19 relief funds. Newzroom Afrika's Mnisi reports.
It was under former Tourism Minister Mamuluko Kubai that Solidarity and AfriForum decided to challenge the department's B-BBEE criteria for businesses to qualify for COVID-19 relief funds. Solidarity and AfriForum took to the Supreme Court of Appeal after the High Court in Pretoria ruled against them. The SCA ruled in their favor, which prompted the department to petition the Constitutional Court.
Chief Justice Raymond Zondo says, despite the matter being moot, there are no other justifiable reasons why the Crown Court should entertain the matter.
In my view, there are no sound reasons for this court to entertain this matter, despite it being moot. The fact that the High Court and the Supreme Court of Appeal in this matter gave conflicting decisions does not on its own carry much weight. It may have been different if we were dealing with conflicting decisions of different courts in different matters raising the same issue.
Despite agreeing that the matter was moot, the Department of Tourism had submitted that a ruling by the Apex Court would give guidance on whether a minister is entitled to use the B-BBEE status as a criteria to disburse funds under the Disaster Management Act. But the Crown Court found that there was no merit to this point, as the department's defense was purely based on the Act and the powers granted therein. It says the state of disaster was terminated and that it may take long before South Africa is faced with another one.
If you look at the judgment from the appeal court, it's set out clearly that in a disaster situation, in terms of the Disaster Management Act, you cannot use BE criteria to allocate funds. So that's a judgment that stands at this point in time. Therefore, it's a precedent, and we will most certainly make use of it in the future.
AfriForum has also reacted to this ruling.
This type of precedent is important because going forward, if the government were to have any other type of discriminatory policies or legislation that they propose or have in mind, they will hopefully think twice, seeing as they now have suffered a very major blow in court.
For Newzroom Afrika on Channel 405, I'm Mnisi at the Constitutional Court in Johannesburg.